Hello everyone, welcome to the 120 Q&A practice. We're going to start off with defense questioning. Ready? Isn't it a fact, Mr. Frederick, that you wrote out a document in your own handwriting from which that document in front of you was typed? Probably yes. Well, now, do you recall that you wrote a document of which this is a copy on the computer? You wrote one in your own handwriting, which has been verified by Linda Buckman. I didn't know it was going to be typed up on the computer. I wrote 3 or 4 of them. All right, you wrote 3 or 4 of them? Yes. When did you write them? Do you recall, sir? No, I don't. Do you recall whether it was before or after the date of this document? Well, to establish that, I would have to know what day Mr. Holcomb got out of jail on bail on the original charges. Counsel, do you want to stipulate that it was April 20? Just a moment. Yes, I will stipulate. All right. It is stipulated that Mr. Holcomb was released on bail sometime on April 20, 2004. Now, with that in mind, when did you write the handwritten copy, the handwritten original of that document in front of you? The same day or probably the next day. In other words, April 20 or April 21? Yes. What happened to that original handwritten copy, do you know? No. Did you take it? No. Where did you leave it, if you remember? If I didn't leave it in the computer, I threw it in the trash. Well, I am not talking about... We are confused here, Mr. Frederick, and I don't want to do this deliberately because we are trying to get at the truth. I have been referring to a handwritten copy, you see. Handwritten copy? Yes, in other words, in your own penmanship or by pencil. We will get to the question of the computer copy later on, but I mean your own penmanship. I don't recall, no. Incidentally, did Scott give you any money? Yes, he did. How much? $580. Is that your signature? Wait a minute. Let me show it to Mr. Phillips. I am sorry. When did he give you the money? He gave me $290 on 2 different occasions. Do you recall what date he gave it to you? One date was when he had been down to Stanton, Louisiana, to see Mr. Holcomb, and the next time was several days after that. Your Honor, may this be marked defendant's next in order for identification only? It will be marked defendant C for identification. Mr. Frederick, one more question and we will get on to some other matter. Do you recall whether or not you actually, whether you did or did not, in your own penmanship, write a document from which this computer copy was made? I might have, but I don't recall it. All right, now you mentioned when we were discussing it that you might have left one on your desk or threw it away. Is that correct? Yes. Now I show you, please again, Mr. Phillips, forgive me. I show you, Mr. Frederick, a yellow piece of paper with some writing on it, and I ask you to look at that. Please examine it. Okay? Did you write this? Yes, I did. We will take a recess at this time for 10 minutes. Proceed, counsel. Very well, Your Honor. Your Honor, I ask that the yellow sheet identified as being written by the witness, Frederick, be admitted for identification, next in order for the defendants. It will be marked Defendant's Exhibit D for identification. Now, Mr. Frederick, I notice that Defendant's Exhibit D for identification bears no date. Now I ask you to attempt to remember for me, if you can, when you wrote that. I was trying to recall that while I was reading it. I wrote a lot of these things on different occasions. I don't recall what I had on my mind when I wrote each particular one. Was this written before Mr. Holcomb was released from jail on bail? Yes, it must have been. And after his arrest? Yes. Is this the truth? I would say all but the last two paragraphs. It is your statement now. Mr. Phillips, should we put a little mark on this as between ourselves before I ask the court to admit it, so that perhaps the witness should mark? All right, very well. I will give you a pencil, Mr. Frederick, a pen, and you just put some kind of a mark around here so the jury will know if they ever see this thing that you know, say these last two paragraphs aren't true. Yes, okay. All right, so we'll switch transcripts. Here we go. This is going to be plaintiff. When he spoke to you about the events of the day that evening, I believe he indicated to you that he had been at a bar drinking, and he went and had some pizza, ate some pizza in his truck, came back and either had one gin and tonic or was possibly drinking the second when he saw this image. Does that refresh your recollection of what he told you about? He was not too definite on the number he had had. He thought he had had one or two, but at that point his memory was not that good, really, as to how much he really had drunk during this lapse of time. Did he tell you he ran out of the bar? Yes, he remembered running out of the bar. Did he tell you anything about his keys being locked in his truck? No. He did recall about the police telling him to get his hands up or get up? Yes, he recalled that. And standing with his hands on top of the car while they searched him, is that correct? Yes. Did he tell you that he then remembers getting in the police car and riding to the hospital? Yes. He remembers you said something about his head being down towards the bottom of the police unit? Yes. He didn't tell you that he didn't know whether it was a car or ambulance, did he? Maybe I misunderstood him. I had the impression that he understood he was in a police car. There is no question in your mind, doctor, that the defendant had voluntarily been drinking. Is that correct? That he had been voluntarily taking the alcohol? Yes. Doctor, you are familiar with Dr. Klatt, are you not? Yes. Is he also connected with the Orange County mental health area? Yes. Doctor, do you have any quarrel with the statement Dr. Klatt makes when he states that he, the undersigned, that Dr. Klatt cannot, of course, attest to the mental condition of the defendant at the time of the incident? I'll object to that. It calls for a conclusion on the part of this witness. He is not aware of what facts Dr. Klatt was using to support his judgment. I'll sustain the objection to the form of the question. Doctor, as a psychiatrist, you can't really attest to the mental condition of the defendant at the time of the incident? It's an option, an opinion. It can't be absolute, definite, and proven, no. And do you agree with the old adage that a man's opinion is only as good as his facts? Yes. So far as the immediate incident, the situation, what was going on in his mind, you were getting this from the defendant? Yes. Isn't it a fair statement, Doctor, that the psychiatric defense of not guilty by reason of insanity has had quite a bit of play in the television and soap operas and movies in the last 10 or 15 years? Your Honor, I'll object to that. There is no foundation, and it's highly prejudicial, I believe, and improper at this time. I'll rephrase it, Your Honor. The question is withdrawn. Doctor, this defense of not guilty by reason of insanity, in your impression, it's not exactly unknown to the layman and the people out in the community, is it? Objection, Your Honor. It is not relevant. Sustained. Okay, and that concludes our Q&A practice for the 120 class.